can I get a confirmation if Councilmember Liao is on the line?
Mayor, I believe he's dialing in as we speak.
Okay, thank you. Hello, Councilmember.
Is everyone in? Because I got, well, okay.
Okay,
No, I'm okay now because I didn't get the phone number.
Okay, no worries. I think at least all the council members are on the line, so I'm going to go ahead and begin. Good evening, everybody. The time is 5:04 p.m., and I'm calling the special meeting of the San Gabriel City Council to order. City Clerk, could you please call the roll, please?
Sure. Mayor Pu?
Here.
Vice Mayor Menchaca?
Here.
Councilmember Costanzo?
Here.
Councilmember Harrington?
Here.
Councilmember Liao?
Here.
Thank you.
Okay. Great. Thank you, Marilyn. So good evening, everybody, and thank you for making the time to join us for this special meeting. Just as a reminder, the mics are live, and the audio is being streamed on our online platforms as well as on our cable channel 3 public access channel. Councilmember Harrington brought up a good point. If you are not at that moment needing to speak, if you could mute your phone, that might help to make sure that the speakers who are speaking can be heard clearly. Needless to say, it's a sobering time. It's an extraordinary time for a number of different reasons. It's the first time that we're doing a meeting via telephone conference like this. Later on, we will still be doing public comment. So for members of the public who might be listening now online or on the TV, you can email your public comments to cityclerk at S as in Sam, G as in George, C as in Charlie, H as in horse, .org. So again, that's cityclerk at sgch.org. And we will accept those public comments up to 10 minutes after we close the regular public comment period to allow for any technical delays, as well as to allow for time for folks to submit comments if they wish to do so. We've taken the approach that we would like to, even though we're doing the meeting under extraordinary circumstances and in this very new way, we've taken the approach that we want to maximize the amount of public participation as much as possible in an effort also to, obviously, for public participation, but also for transparency and accountability purposes. Comments will be read for up to 3 minutes each, and we'll be asking our city clerk's office to do that. Also, once we get to council discussion on the item tonight, to prevent any overlap in comments and folks speaking over each other, each council member will be called upon to speak in order. With that, I'd like to turn it over to our city attorney, Mr. Keith Lemieux, for another discussion item.
Yeah, before we discuss the item before you tonight, I want to talk about an issue that we need to inform the public regarding this discussion and my proposed solution to the issue. So, as you know, tonight's ordinance involves implications regarding both commercial and residential leases and the potential for eviction. As it happens, we have two city council members. We have Mayor Poo and also Councilmember Costanzo. Mayor Poo is I believe you're an owner of rental property, of residential rental property, which could be affected by this particular ordinance. I believe that Mrs. Costanzo is a potential, or is a lessor of commercial rental property that could potentially be affected. So that creates an issue that was brought to our attention about the potential for a conflict of interest regarding this matter. It ends up that we sort of learned of all of this literally moments before the meeting was the final piece that came into place. And so it's a little bit of a scramble because both of those do appear to be potential conflicts of interest, in that the ordinance could have a material financial effect on both of the council members. So that created a number of issues, and I think I've got a solution for you on this one, and that is as follows. So first, the issue is the ordinance is an urgency ordinance, which, unlike ordinary ordinances, requires a 4/5 vote. The other thing about it is that it has a special statute that requires a 4/5 vote. The statute says it's a 4/5 vote of the council, I think is the, Norma, do I have that correct? Is the exact language?
Yeah.
The reason that language is important is that some votes are required to be a majority of the full board, essentially, regardless of whether there's board members absent, or even if there's board members appointed or council members appointed to each position. Some votes are required to be, or allowed to be, a majority of the quorum, or essentially those present. For cities, some decisions fall under one category, some decisions fall on the other. Just to make things more complicated, it isn't always abundantly clear which is which, believe it or not, even on something you would think it would be so basic. In this particular case, we haven't really had a chance to research whether the language, the 4/5 language here, means we need 4 affirmative votes, or whether that means we need 4/5 of the members that are present to vote. So we're going to treat this as if we need all 5 members present, so that we can, or at least 4 members present, so we can have a 4/5 vote. So that raises the issue of this potential conflict. Now, there's a couple of ways around this, in my view. The first thing is that there is an exception to the conflict of interest rule that applies when the financial effects of the decision are indistinguishable from the effects on the public generally. And that means if essentially the decision applies to a broad section of the public or businesses or so on, and it's going to apply to your interests the same way it applies to everybody else, then it's an exception to the conflict of interest rules. I think that this ordinance would apply because obviously it's meant to apply to all leases throughout the city, whether they be residential or commercial. So it seems to me that that exception could reasonably apply here. There's also a special exception when let's see if I got the language right. When the decision is made pursuant to an official proclamation of an emergency, or when required to mitigate against the effects directly arising out of the emergency, and there's no unique effect on the public servant's interest. Again, it seems to me that that exception would apply here pretty soundly, I would think. Finally, there is something called I was calling it the rule of necessity. I think that's not the technical name, but you're required to make or participate in a governmental decision if there exists no alternative source of decision consistent with the purposes in terms of the statute authorizing the decision. What that means is, in other words, if you have to vote, if this is something that the government entity needs to do, and you're the only one available to vote, then you're allowed to go ahead and vote on it, I guess is a simple way of putting it. And again, if a 4/5 vote of the full council is in fact required, then I would think that this rule would also apply to, assuming that there's a conflict, would apply to excuse that. So I know that's a very long discussion I threw at you. To summarize, I think that there's arguably a conflict of interest here. I think based on that, however, that there is a potential exception, or there should be an exception, to both based on the public generally exception and on the fact that you're responding to a declared and obvious emergency. And furthermore, that your participation is likely required because of the 4/5 requirement necessary to adopt an urgency ordinance. So on that basis, I'm recommending that all 5 members participate in this discussion, and that the affected members simply disclose their financial interests prior to taking a vote. Any questions?
None by me.
So I think it would be appropriate if both Councilmember Costanzo and I go ahead and do that full disclosure. Just in the interest of that disclosure, I was preparing to actually recuse myself from the entire discussion of tonight's item. But I'll go ahead and explain the nature of my conflict of interest. In January of 2017, my father, who lived in the city, passed away. So his property is located within the city of San Gabriel. My brother and I went through the probate process and have subsequently now are the record owners of that property, and we do have tenants there. So therefore, that's the nature of my conflict of interest. It was my father's wish that we maintain the property, so that's part of the reason why I continue to hold on to it, despite it actually being a severe money pit. But in any case, we do have residential tenants living at the property, and of course, this ordinance would affect it. But if the recommendation of the city attorney is to go ahead and proceed based on the exceptions that apply to the normal rules, then I'm willing to proceed. I would have been, I was actually quite disappointed that I wouldn't be able to participate on this item. But if that's the case now, then I've disclosed everything, the nature of my conflict of interest, and I feel fairly confident too that my position is based on what's best for the community, what's best for the city, and me wearing my hat as a mayor and council member of the city and not as a landlord. So with that, I'll hand it over to Councilmember Costanzo.
Thanks, Mayor Pooh, and thanks, Keith, for the explanation. My disclosure is I have a warehouse located on Augustino in the city of San Gabriel, small warehouse that I rent on a monthly basis, and we've been renting it for 15 or 20 years. And that's basically it.
Okay, so I'll ask quickly for our city attorney's office, are those disclosures adequate for the purposes that we have in front of us here?
I believe so, yes.
Okay, so this is yet another sort of audible and change of pace, since I was actually preparing to not be on this call. But I guess since we are under the exceptions to the normal recusal and conflicts of interest rules, able to participate, I'll go ahead and continue to preside. The next item on the agenda is public comment. And I think I'll say at the outset, our city clerk's office will, as I mentioned, read public comments that we've received by email for up to 3 minutes each. so that they are made part of the record. I will, go ahead and also take public comment again at the end of the staff report, so that anybody who has comments that come up, I guess, during that staff report has that opportunity as well. So with that, I will hand it over to our city clerk's office. Marilyn, could you please go ahead with the public comments that we've received so far? And also for members of the public, that email address once again is cityclerk@sgch.org to submit comments with respect to this, just with respect to this item. As a special meeting, we don't take public comments with respect to everything that is under the jurisdiction of the City of San Gabriel. Comments will be limited to simply just to this particular item, this urgency ordinance. So go ahead, Marilyn.
Mayor, we've received a total of 2 public comments thus far. The first one I'm going to read is from Juliana Serrano. I'm starting the timer at 3 minutes, starting now. It reads, Dear Mayor and members of the City Council, I write to express support of the emergency eviction moratorium ordinance that is before you today. The City of Pasadena recently passed such a moratorium, and it is critical that all surrounding cities pass this type of measure in order to protect all members of our respective communities. We are living through an unprecedented public health crisis, and it is not the time for landlords to seek removal of tenants from their homes. Doing so will only exacerbate the pandemic and our current housing crisis. Your moratorium must be drafted to include the following stipulations. It must have universal application and must not require burden approved by tenants. Inability to pay rent as a result of COVID-19 should be a presumption. Landlords must be prohibited from filing unlawful detainer cases. Service of an eviction notice during the moratorium period by the landlord, as well as filing of an unlawful detainer case during the moratorium period, shall be complete defenses to unlawful detainer case. No tenant and at any time shall be evicted for non-payment of rent during the moratorium or during the period thereafter. Tenants can pay back rent no less than 12 months after expiration of the state emergency. You have a moral and ethical obligation to serve the renters that live and work in your beautiful city and ensure the health and safety of all during the pandemic. Please pass this emergency ordinance. Thank you, Juliana. That was the first public comment received. The second one I'll be reading is from Sean McMorris, and it reads as the following. I'm starting the 3-minute timer now. Dear Mayor and City Council, I want to thank you and the city staff for bringing this important item before the City Council today for consideration. I am writing to express my support for an emergency eviction moratorium and strong tenant protection ordinance. These extraordinary circumstances require extraordinary measures to preserve livelihoods and the social fabric of the city. All of our lives have been changed as a result of the COVID-19 pandemic, and many lives will continue to be affected by this crisis long after the pandemic has subsided. Cities play an essential role in dealing with the pandemic and corresponding health, economic, and social fallout that will occur as a result of the life-altering event. That is why I support this ordinance with the following recommendations. I urge the addition of the clause in the ordinance that prevents late fees, penalties, and/or interest on payback payment of rent as a result of errors due to COVID-19. I caution against the making of verifiable documentation requirement too erroneous. While some form of verification that a tenant is unable to pay because of COVID-19 circumstances is reasonable and will ultimately be needed if litigation ensues, strict and limiting documentation required or requirements will overlay burden tenants who are already under extreme stress because of the pandemic. For example, if an employer or former employer is non-responsive to a tenant request for documentation that verifies financial hardship as a result of COVID-19, is the tenant out of luck? Please ensure that the verification requirements language in this ordinance is tenant accommodating. Number 3, extensive public outreach and notification should ensue soon after the ordinance is passed. This ordinance will only be effective as the public outreach and notification process the city engages with its tenants and landlords. Therefore, it is absolutely crucial that the city invests in mail notifications to residents about the ordinance. Simply posting it on the website is insufficient. And finally, lastly, number 4, the creation of some form of rental assistance program through the city to help tenants who fall behind their rent as a result of the pandemic. Falling behind 1 or 2 months rent can take far more than 120 days to get caught up on, especially if the tenant remains unemployed for an extended period of time because of COVID-19 crisis and landlord is unaccommodating to such circumstances. Thus, I request the city explore ways to aid tenants who fall into errors where a result of the crisis implement appropriate measure as soon as possible. Thank you for your time and your consideration of this important ordinance. Please pass the meaningful tenant relief today for the residents of San Gabriel. Sincerely, Sean McMorris. And that is all I have received so far.
Okay. Thank you, Marilyn. And thank you to the members of the public who have commented. Could you do one last check to see if any other comments have been received in the time that you've been reading those comments?
Absolutely. Give me 1 second and read it right now. Actually, as you said that, I received one more public comment from Teresa Eisler. Let me read that comment right now. I think this one might go over 3 minutes. Do you want me to proceed in reading the full text, or do you want me to find a way to?
Yeah, go ahead and read the full text up until the 3-minute mark.
Okay, you got it. Give me 1 second. And I'm starting the 3-minute timer right now. Dear City Council, thank you for taking the special meeting during this critical time for your city, our country, and our world. I write to ask Council for strong local action. The current moratorium on evictions order passed by Governor Newsom on Friday, March 27, is an act of good faith, but there are many loopholes in it that do not work in favor of the people that rent. It falls short of providing practical help for renters during the COVID-19 pandemic. The order does not provide additional protection for renters who are unable to pay their rent during this crisis, for renters who may be evicted for other reasons. The order simply allows renters to more time to file a response in court, but only if they have met the conditions and are aware that they have more time. The order does not create an obligation for the landlords to accept the rent at a later date or not to impose late penalty fees, enter into a payment plan, or otherwise work with renters to avoid the eviction. We are asking the city to declare a local state of emergency order that would be retroactive from March 1st, when some people were already affected by COVID-19, until the city calls off the local state emergency. In that order, we are asking the city to immediately enact a sweeping moratorium against all evictions for non-payment of rent or mortgage of any tenant, homeowner, business, or commercial interest that has been impacted by COVID-19 in the city and therefore unable to pay their rent or mortgage. This local moratorium will be effective for 3 months after the local state of emergency is no longer in effect, with payback time of rent up to 6 months, barring all fees or penalties. This will allow people and businesses time to set up small loans to cover rent, mortgages that they will be responsible for paying back. If a person's rent is $1,500 a month and the virus goes on for 3 months, they will owe $4,500. Where does such person come up with $4,500 a month when most people are already living paycheck to paycheck? It will take time to set up loans as the system will be inundated. If a property owner attempts to evict a tenant, homeowner, business owner, or commercial interest for non-payment of rent, it will be considered a violation of the ordinance against evictions and may be invoked by the above party involved as affirmative defense against the eviction in court. The city will immediately send out a mailing English, Spanish, and Chinese to all residents about what is necessary to prevent themselves from being evicted, what are the steps they must take, and what do they need, the deadlines, etc. Translations and languages should be available as well. The city would work with the county to find motel space for motel space set up for master leases of local hotels that are suffering with low occupancy rates. The timer has counted that it is done, and I still have about a page and a half to go.
Okay. Well, we will cut it off there for now, but as I mentioned earlier, we'll have another public comment section after the staff report. So Marilyn, could you then just put a pin on where you've stopped, and so we can continue with that particular comment in the later section, and also provide an opportunity for other members of the public to submit comment. Again, we're only accepting comments on this particular issue, and also only via email under these extraordinary circumstances. And that email address again is cityclerk@sgch.org. So thank you, Marilyn. And with that, let's go to the next item. So could you please read in full the title of the next item?
Yes. Ordinance number 668, an urgency ordinance enacting a temporary moratorium on evictions due to the non-payment of rent for residential and commercial tenants where the failure to pay rent results from income loss resulting from the novel coronavirus. Norma Tabares from the City Attorney's Office will provide the presentation tonight.
Good afternoon, good evening, Council. Norma Tabares here. So I'm not going to go into the detail in terms of the background of the emergency itself. I think everybody is very familiar with the extraordinary circumstances that we find ourselves in. I want to jump into sort of why it is that it's necessary for a local ordinance. What prompted this was initially California Governor Gavin Newsom issued an executive order on March 16th, which essentially authorized local governments to be able to impose these types of substantive limitations on evictions based on non-payment of rent as a result of COVID-19. So what that did is it essentially lifted the concept of preemption of state laws that would typically prevent local governments from enacting these types of limitations or eviction protections. Subsequent to that, last Friday, March 27th, the governor issued a statewide moratorium. So you can imagine from the first executive order, there ended up being a patchwork of responses at the local level. And so the executive order that the governor passed last Friday was really intended to establish a floor. So it was a statewide moratorium that suspended residential evictions only, and it had, certain very basic requirements that were set in place. So things such as, again, non-eviction for payment of rent, but really it's not a ban. It was essentially like a 60-day extension for when a tenant would typically have to respond to an eviction summons, which under normal circumstances would have been 5 days. It also prohibits enforcement by the courts, and so that's the skeleton framework that the state implemented, and so it still allows for local jurisdictions to go deeper. So there's still flexibility at the local level to consider both the breadth and duration of what these protections might be required at the local level. And so the ordinance that's before you tries to strike a balance with those protections that we're trying to implement for tenants, and at the same time being mindful of the realities on the ground of downstream challenges that might impact landlords who rely on rents to pay mortgages, taxes, and other things. And so the idea is that this ordinance is construed to be narrow to this particular situation, but does not preclude evictions that may happen, just cause evictions that would still, where landlords would still retain those rights. And so what's laid out in the draft before you essentially is that it covers both commercial and residential tenants. It does require that documentation be provided to support the assertion that tenants are in fact impacted by COVID-19. It's not a presumption. It creates a 14-day window for tenants to reach out and notify landlords. The state ordinance has only a 7-day window. The duration of it is tied to the state ordinance, but it expands it by an additional 30 days. So currently the state ordinance is in effect through May 31st. So the local ordinance is drafted so that it would expire 30 days beyond whenever the state ordinance would expire as extended. It also it puts in some requirements for who would qualify as a commercial tenant. So it's not a blanket protection for every single commercial tenant in the city. There's a certain cap, and the idea here, and this would be a policy decision, but the way it's drafted is that it's really intended as more of the smaller local businesses that would be more severely impacted as opposed to larger national businesses. And then other things that would be that would need to be decided at the decision point is this concept of a payback period, how long tenants will be given as a right to pay back the rent that will accrue over time. And so as currently drafted, it's 180 days, so 6 months. Other cities are, we've seen a range from anywhere from 4 months up to a year. And so the way it's currently drafted, it's at 180 days. So again, in considering all of this, I think it is striking that balance between putting protections in place that rise to the moment, and at the same time recognizing that there are some downstream challenges that would have a trickle effect over time, both with respect to landlords as well as tenants, depending on how long the crisis lasts and how long it takes us to get out of it. So, but it is our recommendation that the City Council adopt the Urgency Ordinance 668, but there are certainly some decision points that are available for the Council to consider. Any questions?
Great. Thank you, Norma. I think at this time, why don't we go ahead and go back to public comment, and I'll ask the city clerk if any additional or new public comments have come in during the staff report.
There are no new public comments.
Okay. In order to afford the public, as much of an opportunity to participate as possible, you can start the 10-minute timer now, Marilyn, if you could. Any comments received then within the next 10 minutes as well will also be read into the record and presented to us, prior to the vote. And with that, though, we'll go ahead and start with council questions on the staff report and the urgency ordinance that's before you. Again, we'll go in order, and then after questions, these things may bleed into each other, but let's try to do clarifying questions first, and then we'll do council discussion after that. So first, Councilwoman Costanzo.
Caught me off guard. Thank you, Mayor Pooh.
You're
So just to clarify, this moratorium, we're extending it 30 days past what Governor Newsom, March 27th. Is that correct? You said to May 31st, or?
The statewide moratorium is in effect through May 31st, and so the way our ordinance is drafted, it would be 30 days beyond that. That May 31st date gets extended, then ours would automatically extend.
Okay. And then it was mentioned that, or advised that we give written notice to all of the tenants. So I'm assuming we have that information available to us?
Mayor Pu, this is Mark Lazaretto. We don't have information as to who is a rental household versus who is an owner household. So if that is something the council would want us to do, in addition to posting on social media and our other platforms, we would have to send a notice out to every address in the city.
Every address, whether it's a rental or just a regular homeowner.
That's correct, because we have no way of differentiating between the two.
And I'm sure you haven't had time to figure out costs on that, but it would be something that I think would be important to know. It is important to, I believe, to contact everybody. And then also, more importantly, too, is to get the word out to the landlords or the property owners.
That's correct, Councilwoman Costanzo. We have not had a chance to figure out what that cost would be, but we could do that if that were the desire of the council, to notify everybody in that manner. And
okay,
it would be likely a couple of $1,000s or in that range to send a letter to every address in the city.
Thank you, Mark. I appreciate it. That's my questions for now.
Okay. Thank you, Councilwoman Costanzo. Councilman Harrington.
Thank you, Mayor. There was a reference to mortgagees. I didn't see that in this ordinance. Is that something that came up later? I looked through, I didn't find anything about, I'm not talking about tenants, I'm talking about the downstream mortgagees. I didn't see that anywhere.
Yeah, this ordinance does not consider mortgagees. There have been other orders passed at the state level where there's been recommendations for banks and financial institutions to offer moratoriums, but at this point it's not required, it's recommended, so there isn't necessarily, so every owner will not necessarily get some sort of downstream protection from the mortgage, from the lender.
Yeah, the reason I said, is that something we can put in here, or is that beyond our jurisdiction?
That would be something, I mean, based on the executive orders that we relied on for this particular action, that would be beyond the purview. I mean, it's certainly something that we could look into as a subsequent action.
Yeah, because the reason I bring that up is the fact that if you have, let's say, a 20-unit building and 18 units aren't paying their rent, very quickly you're going to get foreclosure.
Right.
If you're not, obviously the landlord can't afford to keep paying the mortgage if the rent's not coming in. And then, there's other things that can happen because they can't pay the water bill or the gas, the trash hauling and other things. So that can cascade very quickly if we're not able, we have no jurisdiction over that. So we would need to communicate that to the state and to the county. The fact that we're doing this and we're protecting, obviously we're protecting the renters, but what about, the renters are paying rent to, or would be paying rent to somebody, and some of these banks can whip up a mortgage default pretty quickly. I mean, faster than this may be over there. And in that case, if there's an actual mortgage default, then it's defeating the purpose of this, because then the tenants will be removed because of the mortgage default.
Yeah, that's a very legitimate concern, and there are protections in place, at, both at the federal and state level. There are starting to develop these funds that owners can tap into. So the purpose of this executive action was really out of criticism that there were protections being put into place for mortgage holders, but there really wasn't anything at the tenant level. So at this point, again, it's not required, but they're advising mortgage holders to reach out to their financial institutions. But yes, that's certainly a legitimate concern that, you know, this ordinance doesn't address.
It could be the subject of a future urgency ordinance if Councilmember Harrington, if we determine we have the power to do it. The particular urgency we're responding to tonight is, you know, we've got the first of the month coming up, and this may be the first round of evictions that we're facing right now.
Yes, I understand that.
And if I may interject, is either any member of the city attorney's office or a member of the staff prepared at this point to summarize what those state and federal protections with respect to foreclosures are to this point? I know there's still a lot to be determined, but if is there any broad strokes summary that is available?
Norma, I'm looking at you.
Yeah, I was going to say, yeah, only to note that there are some, but I mean, that's certainly something we can follow up in writing and provide in summary form.
Okay, thank you.
Mayor, there's 3 minutes left to submit public comments.
Okay, thank you, Marilyn. Appreciate that.
And
I
Mayor,
think the rest
from
of my
perspective in summarizing the actions that have happened so far, the only thing I'm aware of is that the state of California, Governor Newsom worked with several leading banks that they would be holding off on foreclosures. But that, if I understand the information correctly, is voluntary on their part, and it was an agreement that he came to with those banks and not something that was enacted statewide. There were 4 or 5 banks at the time of news that had joined on. So if you wanted a deeper dive into that, staff could bring that back at some point in the future, as Mr. Lemieux said, or even as part of our April 7th council meeting.
Okay, thank you. Go ahead.
And mine is more of a question. Yeah, mine is more of a question on the jurisdiction, because I don't know that we would have that jurisdiction because, you know, obviously banking is regulated at the federal level. I'm not even sure that's why. I think if Governor Newsom could have done it, he would have done it. But I don't think that he's able to do that. The state doesn't have that power because they don't charter the banks. And the other issue is, what if it's not a bank loan? It could be a private loan as well. So there's a couple things there. So I'm not sure that we have that. I just wanted to see if that is something that, if we're mindful of that in this as well, if that's something we could do. And I think the balance of my questions are more policy/council, not questions of the ordinance itself. So I'm good to go if you want to go to the next member.
Okay, thank you, Councilmember Harrington.
Mayor, there's 1 minute left.
Okay, thank you. Again, that's cityclerk@sgch.org for council for public comments. Councilman Liao, clarifying questions with respect to the staff report.
Okay, so I just want to follow up with Councilmember Harrington's comment. Yeah, Governor Newsom, you know, talked to 5 banks, the major one, Chase, Wells Fargo, Bank of America, asked them to defer mortgage payments. But however, it's not easy because, you know, maybe governor has good intention, but this is, again, under federal jurisdiction. So, but I did try to contact them, but as I understand, the borrowers have to sign some kind of agreement. It's called forbearance agreement. So it's too early. So I don't know if these banks can help. But my question, hello?
Mayor, the public comment period submittal has ended.
Okay, thank you very much, Marilyn. Go ahead, Councilman Liao, your question. I think we're all here.
Regarding this urgency ordinance, back to governor's executive order, I guess allow 7 days for tenants to give notice to the landlord and say why they're not able to pay rent. My question is this mandatory? 7 days after due date of the rent.
Is it mandatory? In the ordinance as drafted, we've extended that notice period to 14 days, and so we are making it a condition of being able to avail themselves of these protections. And so as drafted, yes, that would be considered a requirement.
Okay. So, yeah, so the tenant has to give notices to landlord and say why they're not being able to pay the rent within 7 days of the rent due dates. Another question is, well, because we want to help these tenants, but then we give 120 days for them to catch up paying the rent. 120 days, that's 4 months. Okay, and for instance, if right now it's April, May, and then all the way to September, that will be 6 months of rent. And so that's my question. How do we come up with the 120 calendar days to pay unpaid back rent?
So I believe the last version of the ordinance, that period is longer. There was an earlier draft that said that was 120 days. That's now been revised to 180 days. And the idea there is to be able to give enough of a runway to tenants to be able to catch up, because this is not, what the ordinance doesn't do is basically tell tenants, oh, you don't owe rent at all. It's just giving them, it's essentially just suspending the timing for them to pay for it. And so that payback period really is a policy decision that would need to be made, that that would reasonably give the affected tenants time to not only pay what's current when that time comes, but also catch up on all the rent that may be in arrears. And we should recognize that some tenants may not be able to pay the full rent, but they could still pay partial rent. So, that's a scenario that could be considered. They may be coming up short month after month, and some of them may not have anything. They may have prioritized food and utilities over rent, depending on their circumstances.
Okay, so I think 120 days sounds reasonable, and maybe what landlords should do is asking tenants to come up with a payment plan, because they have to pay the future rent, for instance, June through September, and then pay the 2 months that they owe. And if you divide by 4 months, that means they have to pay additional 1/4 of monthly rent every month after June. So that, it could be up to the individual tenant if they can afford to come up with this type of payment plan. Last question. So for just cost termination, so for instance, if there's a
Councilmember Leon?
Yes.
Let's save our discussion with respect to the substance of the ordinance for council discussion a little bit later, if that's okay.
Okay.
This is just clarifying questions with respect to the staff report at this
Sure.
point in time. Okay, thank you. And just to clarify, the current draft of the ordinance that's before the council now does have the 180-day period for payback of rent that's not paid during the effectiveness of this of the ordinance. So it is 180 days, not 120 days. and just to address one of the questions as well, that the 7-day notice period under the governor's order is mandatory throughout the state. We are, under the current draft of this ordinance, extending that to be 14 days. So allowing tenants more time to be able to avail themselves of these protections. So just wanted to clarify that for members of the public as well as the council. Vice Mayor Menchaca?
Yes, thank you, Mayor Pooh. So a couple of questions regarding, I know the new draft includes other sources of income. I will assume it includes, it was added to expand the scope. So we're making reference to individuals who are self-employed, freelancers, contractors. But does that also include inactive income, for example, dividends, maybe retirement plans? Is it just all income, or is it just, if you can just clarify?
Yeah, I mean, the spirit of the ordinance is to protect those who truly cannot pay the rent as a result of COVID-19. So if there is, you know, all individuals who can pay their rent should pay their rent. And so the idea of, you know, considering all sources of income is to take that into account, that even though somebody may have a reduction in, let's say, wages, but they have passive income through other means and can still afford to pay their rent, then that would be the default. You know, so long as, you know, again, depending on their circumstances. But that's what that's trying to get at. And again, this is not intended or designed to cover people who can afford to pay their rent.
Okay, thank you. And under section 5.5, there is reference to commercial tenants, and it talks about tenants that have gross receipts of less than $5 million. And my question is, how did we come up with that $5 million number? And there doesn't seem to be any appeal process. So let's just say, for, you know, they happen to have a banner year the year before, but it's not a recurring, you know, income. But that's how we're going to measure them. And if it's over that $5 million, then it doesn't apply. So, you know, so there's, I guess that's multi-pronged. How do we come up with the $5 million, and why isn't there any kind of appeal process so they have an opportunity to explain that perhaps you can't just look at the prior years? That's just doesn't really describe their business as a whole.
Yeah, thank you for that question. In terms of the $5 million number, that was a number that was discussed with staff, and given the nature of most businesses in the city, that seemed to be a high enough ceiling where it would cover most, if not all, commercial entities. But there's no, there's like that number again would be a policy decision for the for council members to make, you know, whether you think that that's extensive enough. You know, the idea here is that we're trying to be as broad as possible while still trying to target the people who actually need the help. The second part of the question in terms of the appeal process, you know, that is something that we can potentially add, because you're right, right now there is sort of a catch-all provision in the event that there's some unique circumstance for a commercial tenant that wouldn't fit within this definition, but may still have suffered significant financial loss and would still want to avail themselves of the protection. So that is something that we could consider adding.
Vice Mayor Menchaca?
Oh, I'm back. Sorry about that. So lastly, is there anywhere in this document that prevents any type of penalties or fees or penalties of any sort for the tenant if they do fall behind? Because I couldn't find anything.
This ordinance does not add protections with regard to either prohibiting landlords from increasing rents during the moratorium or assessing late fees or penalties. That is certainly something that the council can consider and propose to add to this. But
have you seen that added before? Or have you seen it added in other ordinances?
Other cities have added that additional level of protection, yes.
For fees or penalties or some type of punitive damages.
Yeah, we're in addition to being prohibited from starting an eviction process, landlords are also prohibited from doing those things, assessing penalties, late fees, and raising.
Okay, thank you. That's all for the clarifying questions.
Thank you, Vice Mayor Menchaca. Let's see, for myself, I wanted to just clarify with respect to under the just cause termination section 8, it was to be subsection A4, Ellis Act removal. Could you explain for all of us what an Ellis Act removal is and sort of the basis upon which that would still be a justified eviction even during this, extraordinary emergency circumstances?
Sure. So Ellis Act removal is it's state law that was passed, I want to say back in the 80s, and it was really at the time intended to prevent local governments or prevent landlords from evicting tenants in areas. Really, the issue is more having to do with rent control, and so areas where there's very restrictive rent control ordinances in place. And so it's what you would consider an earlier option, where a landlord would completely remove units from the rental market. And so usually the purpose of that would be things like they're going to, it will become owner occupied, or it might be where there's 4 units, it's a multi-complex unit, and the owner intends to convert it to a single family. It's also used in converting apartments to condominiums. And so, again, the idea is that we're entirely taking the units off of the market. And one unique aspect of the Ellis Act is when an owner does that, you have to put it on title. You have to record it on title so that it's something that then runs with the land. The reason that we left it in here, there's a couple of reasons. First, it's in exercising their right, a landlord would typically have a pretty long runway of notice for tenants. There's 120 days notice under the Ellis Act. So already there's this very long period of time that would be required if an owner were to exercise this. Even if we remove it from the just cause section, landlord would still have this right to evict under the Ellis Act. If this was something that the city wanted to prevent, similar to the penalties and late fees, et cetera, this is something we would have to affirmatively ban. So it would be an affirmative language as opposed to just removing it from the list of just causes. That's not intended to, that section is not intended to be all-inclusive. It's, the purpose of that section is really to underscore that landlords still can avail themselves of other reasons to evict tenants, irrespective or outside the scope of what this moratorium is intending to do.
Okay, thank you. Thanks for that explanation. Okay, at this time, City Clerk's office, have we received any additional public comments within the 10-minute period?
No, there are no new additional public comments.
Okay, thank you very much. And with that, I'm formally closing public comment. We will begin council deliberation and discussion. Again, this is going to be a work in progress here, since it's the first time we've ever done council meeting via telephone conference, but we'll try to go in order. And and we'll just see how it works, because you know, oftentimes I found our discussions are best when we have the ability to talk with each other. But at the same time, if we have too many voices speaking at the same time, it'll become a little bit chaotic. So why don't we go ahead and start with Councilwoman Costanzo again.
Thank you, Mayor Pooh. I'm in agreement with basically everything in here as written. I do agree with putting in the clause about no penalties for the time that, you know, they're unable to pay and then have to pay back. I would like to see that included.
Okay.
And that's pretty much it so far.
Great. If I may ask, with the City Attorney's Office, how difficult would that be to insert, you know, protection with respect to late fees and penalties as well?
It would
Are you saying to insert that tonight?
I guess so. Maybe you can advise. I know there are some rules with respect to how much we can, you know, amend during the meeting when it wasn't perhaps, you know, noticed beforehand. So why don't you go ahead and educate us about that?
Well, you can amend this tonight, since this is being done as an urgency ordinance. You're allowed to amend it right now, provided we can wordsmith it correctly. I guess there's a practical question of what exactly are you asking for, and how well we can do that live. Do you have a thought on that, Norma?
I had a technical question before we go into that, Keith.
Go ahead.
Okay. Would there be a Fifth Amendment takings clause there for interfering with contracts? Because that's a contract clause. We're getting into the very minutia of different people's contracts. And then does that apply to commercial as well as residential? Because I could honestly see where there's a big issue where, let's say, for example, a landlord is not able to pay their taxes because of this, and they're penalized with taxes, and they can't pass that on to tenants who caused this. So how are we handling that as far as a policy issue? And would there be a colorable Fifth Amendment takings clause argument?
Well, it sounds like part of that is a policy question, but as far as the legal part of it, which is when you say takings, what you're saying is, will the city be then responsible for taking private property and therefore have to repay somebody that? My answer is I don't believe we would, for the reason that we are doing this pursuant to a valid emergency declaration that has, you know, obviously exists on every level of government right now. And therefore, that gives our police powers broader authority when we're acting in order to preserve public health and safety in light of a valid public emergency. I hope that answers your question. As far as the second part is concerned, you know, that's something for you guys to talk about, I guess.
Well, I mean, I'm talking about the Constitution. I'm not aware that we can violate the Constitution, because that is a contract right, which is property, and we're taking it without just compensation.
Right, but there is also recognized court authority for the proposition that you can take private property without compensation when you're responding to a genuine emergency.
And that's been litigated on a moratorium like this?
No, has not. I can't tell you that.
I'm just worried about city's liability because we're going well above and beyond an actual ordinance where we're protecting the tenant, and we're getting into the level of interfering with the contract between the tenant and the landlord. That's a whole different level of,
right.
Obviously that's a policy issue. I wasn't aware of any case that said we have that power.
We had this discussion kind of more in the abstract when we adopted the emergency declaration. And after that, I had an associate go and pull authorities for me and create a memo, which I gave to Mark. I don't think that ended up getting circulated to you guys, but the upshot of the memo was my recollection was correct in that there is authority when you're responding to conditions created by an actual emergency in order to preserve public health, then the ordinary requirement to pay for public property that's being taken, or private property is being taken for public use, doesn't apply. Now, you've just raised a separate question, which is impairment of contracts, and obviously I'm not aware of any case in this particular context. So, I have to be somewhat cautious here, but it is consistent with existing case law.
All right.
Okay.
And I guess I should point out that the other practical consideration is we're not alone. We're not the longest nail in this particular situation that's going to get hammered down first. We would be joining the state and the county and numerous other cities that are also taking this action to one extent or another. So in the event that it would be a team fight.
All right, thank you both. I think I would note that the best place, if we were to operationalize a waiver of late fees and penalties, and I think Councilmember Harrington's point is well taken with respect to commercial tenancies, that perhaps that those types of penalties and late fees, shouldn't be waived. But on the residential side, I could see a good policy argument to do that. And if we wanted to, we might be able to insert a sentence in section 7C on page this is 8 or 6 of the ordinance, as that's the section that also deals with what the time frame that tenants would have, affected tenants would have, rather, to repay any unpaid rent. Just seems logical to me to put any modifications to the payment obligations under a lease all in that one section.
If I can offer an alternative place, I think if we look at section 6, that's where we're affirmatively declaring the moratorium, and so I would suggest that we would add a sentence or some language around, I'm just looking at it now, like may not terminate tenancy of a tenant who qualifies as an effective tenant for non-payment of rent, and may not charge penalties, late fees, et cetera, and doing it there as an extension of that, within that paragraph, which is section 6A.
Right. Yeah, I think that would work too, just a general reporting statutes.
That's where they're saying they can't serve notice, they can't terminate a tenancy, and they can't charge late fees.
Can't charge. Yeah, can't know what. Yeah, I think that. Yeah, I agree. That's probably a better place. Okay, well, let's see here. Let's continue. Councilman Harrington, did you have other policy? I mean, I know you do, because you said so already. To ask about, with respect to the substance of the moratorium.
Yeah, one just quick clarification on our last topic that when we just discussed. I wasn't trying to differentiate between commercial and residential. I was just trying to point out the policy of whether we should go to the level of interfering with contract or not. So I wouldn't differentiate commercial from residential. I think if we're going to do it, we should do it for both. So the next question I had is for the council as well. It's a policy question. So I know we don't have a whole lot of businesses with the regarding the cap of the $5 million. But to me, that I don't think we should put a cap at all. We should just leave it at whatever their income is, because some of the larger, I can think of some of the larger businesses that would have a huge detrimental effect on our tax base if they were somehow forced out of business because of a landlord-tenant dispute. I don't know the case of like whether, for example, whether the Hilton has a mortgage or whether the Sheraton has a mortgage or whether it's owned outright. But just the fact that they have a lot of money doesn't mean we shouldn't protect them. By a lot of money, I mean revenue, not necessarily have a lot of cash. And those are the businesses that are being affected probably the most. So their ability to make a mortgage or make a payment may be even more inhibited than some other people or other businesses. So I don't believe we should have a cap. If we're going to protect people, let's protect everybody. That's a council policy level thing. I think if we just took out the $5 million cap, let the landlord and the tenant figure out how they're going to make each other whole and how they're going to pay back. But I think we should protect some of our larger businesses as well because they employ a lot of people, and if they get into a huge dispute, it could have a ripple effect on a lot of other people in town as far as employees, other tenants in the same units. So I think we should just, in my opinion, take that out altogether. So on that, we can have a discussion. I don't know how the council feels. The other part, there's one more thing. I really think if we pass this, we do need to communicate with the county to see what they're going to be doing as far as tax bills, because this will have a downstream effect of landlords' ability to pay taxes, because they may have to decide, do I pay my mortgage? Do I pay my taxes? Possibly we can work with the county to get some tax deferrals. If it actually does go to an issue where a landlord, let's say with a lot of tenants that are affected by COVID are not able to make their payment in a timely manner, because April is, the next tax collection also. So we have to look at that. What if it started in March and they're not able to make their payments, and then the landlord was, a lot of people do their lump sum payment in April and December. So we might want to be communicating with the county. Obviously, we can't address that in the four corners of this ordinance, but it's something I think staff can work on and just see if the county is doing anything about that. As far as giving some delay in collection of property taxes, which I think, obviously it's the same thing. They would have to prove that they weren't able to collect because of COVID. And obviously that is a county decision, but I think that's something we should communicate. And then the last comment is regarding the signature block. And I think we, at the beginning of this meeting, changed the fact that Jason is still going to be running this, and it still says, the red line shows Vice Mayor Menchaca as the signatory. It should still be Mayor Pooh. Those are the extent of my comments.
Okay, great.
Mr. Mayor, I'm sorry to butt in, but I have this is Mark Lazaretto. I have a response to Councilman Harrington's question about tax collection. We talked with the tax collector, we being the city managers of the Valley, talked with the tax collector earlier this week, and there's nothing in the law that allows them to delay collecting the taxes. It's state law. However, they are setting up a rapid appeal process for penalties. And if folks, businesses or residents can't pay their taxes on time, they can go online and file for that appeal and be able to get a determination about those penalties being waived. It wouldn't waive your taxes being paid, but it would waive the penalties. I will reiterate what the tax collector said, which is that governments from the top of the state down to the city of San Gabriel rely on those fees. So if folks are able to pay those, we would urge you to pay those on time. But for areas where you're in a situation like what we're talking about, go online and go through that process if you can prove that you have a difficulty related to COVID-19. Thank you.
Great, thank you, Mark. Yeah, that's absolutely correct. Let's see here. Let's go ahead and take the discussion on the gross receipts limitation for commercial tenants. And I know Vice Mayor Menchaca had also touched upon this issue in the sense that there's not written in here an ability to appeal any of this if a tenant felt like they should qualify but don't under the sort of black letter of the ordinance. So I think I agree that we would that the gross receipts limitation of $5 million is a bit arbitrary. That also gross receipts doesn't necessarily even necessarily reflect net income. A business could have gross receipts of over $5 million and still even have negative net income. It depends on what their expenses are. I also would, so I think I would support the idea of removing that Romanet Clause 3 and adding perhaps a section that could allow for potentially for some tenants. Well, I guess if we remove the Romanet 3, then it's pretty broadly drafted so that it would actually apply to all commercial businesses. So in that case, there might not be the need to have a sort of a separate discretionary process. Those are my initial thoughts on that. Councilwoman Costanzo?
Just to step in there real quick, I just thought that was a cleaner way to do it. I think it's a much easier way, and there's no test at that point. It's just, are you a tenant?
Right. And if you were you required to cease or reduce your operations due to COVID-19? Again, most likely that applies to almost every commercial tenant.
Yep. Okay.
Yeah, Councilwoman Costanzo.
And you're asking if I agree with that?
Yeah.
Yes.
Okay. Councilmember Liao.
Yeah, because our hotels probably bring in gross receipts more than $5 million, and actually some of the large restaurants, they bring in more than $5 million, and the supermarkets too. But so I would agree, don't put a $5 million.
Right. Okay. Yeah, those are good examples. Vice Mayor Menchaca.
Yes, I agree too. It would make it easier because I was going to say, either if we're going to leave the $5 million to add the appeal process, but it just makes it cleaner if we just remove it. So yes.
Okay, sweet, great. I think we have unanimous consensus on that. So we can. I'm making note of it here, and I'm sure city attorneys, you guys are making notes as well. Let's move on then to comments of Councilmember Liao.
I'm sorry, can we just clarify before we move on? We have consensus on removing the $5 million. Do we also have consensus on adding the language about the waiver and penalties? That's also, I didn't hear you go council by council person, so I just want to make sure that everybody was on board for that change as well.
That's true. Why don't we do that later on at the end, because I think that's going to come up again anyway.
Okay.
Let's just move on to Councilmember Liao first, and then if that's part of his comments, then we can do the roll call at that point.
Okay.
Okay. Thank you, Mayor. So back to that Ellis Act removal. I guess the landlord has to pay some kind of relocation fee or assistance, but I don't remember St. Gabriel has any code that apply to that. The guideline, how much the landlord has to pay to ask the tenant to relocate. So I was wondering, are we going to use the state law or what? Or I don't, that's my question. regarding removal or relocation assistance fee.
And I guess to add to that, do we know what state law says with respect to those relocation expenses?
I don't know off the top of my head. I'd have to go back and take a closer look at the requirements.
Okay. Okay, that's.
But there are, when this type of eviction does happen, there is some sort of expectation of compensating tenants for relocation, like the actual dollars and cents. Again, I'd have to look up.
Right, but it varies, as I understand. You know, it depends on the reason why the tenant has to relocate. Okay, so another question is back to that 120 days to pay back the rent. Mayor, you said 180, but in our ordinance is 120 days. So I just want to verify, is it 120 or is it 180?
The latest draft that I saw circulated says 180 days.
Okay, the one that I have is 120.
Right.
Yeah. So, well, even 180, I think it's good. You know, however, I think if this price is prolonged, according to the, this is not very good. The Fed comments today, 32% unemployment rate. So for people to go back to find jobs, it's going to take a while. But there's a solution that I want to mention. It has nothing to do with this, but because the $2 trillion passed, it's called the CARES Act. There is 1.25 billion for tenant-based rental assistance. So $1.25 billion for tenants, and that's through HUD to issue Section 8 vouchers for seniors, disabled, and low-income working families. So in other words, people just have to apply for Section 8. Okay, the last question is the criminal. Say if there's a criminal act in one of the unit in a building, can landlord evict these tenants if they're already conducting criminal acts during this moratorium?
Norma, do you want to take that?
Yeah. So yes, to reiterate the earlier point, this moratorium is narrowly intended to protect individuals that are affected by COVID-19. It's not a ban on all evictions for all circumstances. So the section that we put in there as at just cause termination is an example or a non-exhaustive list of other reasons that potentially landlords would still be able to evict tenants. Whether from a practical perspective they'll be able to, given the fact that courts are, operating on a very limited scale, is a different issue. But in terms of stripping landlords of every right, of every single reason that they might affect or evict a tenant, that's not what this ordinance is trying to do. It's narrowly trying to protect tenants, provide protections for those that are unable to pay rent because of the financial impact of COVID-19 and the government's response to it.
Okay, thank you.
Okay, are those the extent of your questions or comments on the ordinance?
Yes.
Okay. Thank you very much. Vice Mayor Menchaca.
Thank you, Mayor. Regarding the fees and late fees, I just sent to Keith and Mark and Jason, our mayor, some suggested language from one of our neighboring cities. And it reads as follows: a landlord should not impose, charge, or collect a late fee or equivalent surcharge for any rent payments which were unpaid due to the financial impacts related to COVID-19. So I just wanted to assist in some way, and if you can please take that in consideration as we amend the current ordinance as it reads. So that was the first item.
And Norma, I've passed that language on to you via email.
Oh,
Yeah,
okay.
I saw that. Yes, thank you.
Okay, so when we get to that point, we can work through it. Let's see. I wanted to just also pose the question that if we had any concerns that 6 months isn't enough, that maybe we should have it longer. I mean, we can at a later time, maybe 3 months from now, or since this pandemic keeps extending itself, and I mean it's daily. There's always seems to be changes. We can always come back and reevaluate it and extend it if necessary. Is that correct?
Yes, it is.
Okay. Because I think there might be some concern, but I'm comfortable with the 6 months or the 180 days. And that actually came later this afternoon, Councilmember Lau. So you might want to check in the updates, but it did come a little later this afternoon. It changed from 120 to 180, but I can see where there can be some confusion. Also, I wanted to kind of go back to what Councilwoman Costanzo had mentioned earlier. I completely agree with her comment regarding contacting. And what I'm thinking is, there's so much information currently on the website that not everyone has access to, or social media for that matter. And so perhaps it could be all encompassing in multiple languages. I've sent some samples from other cities to our city manager, where we talk about COVID-19. We talk about the fact that we still have city services. We still have our first responders out there, protecting us and making it a top priority. And so that information, along with this moratorium, if it does pass tonight, I mean, that could be just one big grapevine or whatever kind of publication we want. But there is still a tremendous need to inform our community, especially because it's multiple languages out there, by mail. I mean, that's something that I feel is a gap right now, and I think it could be very helpful. So I just wanted to kind of add that in here during the deliberations, and we don't need to vote on it, but I just wanted to share my agreement with Councilwoman Costanzo. And I think everything else I'm comfortable with, and I'll just pass back to Mayor Pooh.
Thank you, Vice Mayor. Why don't we go ahead and address the issue of the charging of late fees and penalties now as well. And I think I really do like Norma's suggestion of if we were going to do it, we would, basically add it to the second sentence of Section 6A, so that it is also time limited to being during the term of the moratorium. So I guess Vice Mayor Menchaca, would you support also providing that kind of relief for the for tenants? And I guess also, a sort of corollary question is, would your position be different with respect to residential tenants or commercial tenants?
I'm glad you brought that up. That was the last thing, actually. Yes, I agree with Councilmember Harrington's comments that this needs to be for both commercial and residential. We shouldn't be differentiating them. I think we need to protect all of our landlords, regardless of what kind of property they have. So, yes, it should apply it to both residential and commercial.
Okay. Councilmember Liao?
Yeah, I agree. actually, I think it wouldn't be fair if these critical situation we ask, landlord asks for late fee and penalties. It's just not right. So we should raise that.
Okay. And Councilwoman Costanzo, I know you sort of generally agreed, but what about the point of differentiating commercial and residential tenants?
I think both should be included.
Okay. And Councilmember Harrington, any change of position?
No, just based upon the city attorney's guidance, as long as we're not facing any issues as a city by going into that as far as takings or like that, if he's clear on that, I'm fine with it.
Okay, for both residential and commercial?
Yep.
Okay, my question then with respect to it would be on the commercial side, I can see definitely wanting to provide relief from late fees during this period. Normally there would be, that each of these sort of categories would be separated out in the commercial lease. So I'm wondering if the term penalties is a little bit too broad. However, I guess I'm concerned that if there's I would definitely want to exclude let's say damage to the property, things along those lines. I'm wondering if there's a way of drafting it that might make it sort of tailored for really just for late fees. And let's see here, the language I think that Vice Mayor Menchaca proposed. Could you read that again, Vice Mayor Menchaca?
Yes, I did send it to you also, Mayor. It reads as follows. Oops, sorry, my screen just went blank. Okay, here we go. Okay, a landlord shall not impose, charge, or collect a late fee or equivalent surcharge for any rent payments which were unpaid due to financial impacts related to COVID-19. So it does not say anything about penalties.
Right. And actually, I think that language would, in my mind, be more precise, because the part that I think is also so that it would exclude other kinds of rent damage is that it's related to rent payments, which were paid.
It's very specific, relating to rent payments. So I think it reads very well. It's direct.
I'm just reviewing this in my head here. And I guess that comment would also apply on the residential side too. I mean, if a residential tenant causes damage to their property, or there's other penalty provisions for that are just related to liability, those are not. I don't think that those types of liability should be excused. So I guess I'll propose then adding to the end of that section, second sentence of section 6A, or impose, charge, or collect a late fee or equivalent surcharge related to any non-payment of rent.
Well, for any rent payments which were unpaid.
Well, I'm trying. I think I think I would try to tie it back to then tie it back to this ordinance itself. So it might be a bit circular, but to say to any related to any non-payment of rent.
We can say for reasons stated in this ordinance.
And Mayor Pooh, the language that you're referring to is what Alhambra put in their ordinance.
think similar, but I think it seems like it seems sort of differently structured, but I think it would get to the same place, you know, essentially. So I do think that there's that a little bit of added benefit, that there's some consistency, you know, a little bit of consistency from jurisdiction to jurisdiction related to non-payment of rent. So I guess I would maybe end that clause by saying, related to any non-payment of rent as provided under this ordinance. I'm going through so many different little prepositional clauses in my head in connection with related to this or that, but I guess, you know, hopefully the concept of what I'm trying to convey here is clear enough. Does it make sense, what I'm trying to say?
Yeah, so rather than saying which were unpaid due to financial impacts, it goes back to saying which were unpaid due to any reasons stated in this ordinance or reflected or related to this ordinance.
Yeah, I think that would be, I think that would get us to the same place. Because the point is that we do not have in this ordinance a definition of financial impacts related to COVID-19. So rather than have to import another concept and so forth, you know, I'm trying to use what's already here, a defined term, you know, under these, under 7A, there's sort of 5 various subsections. So if you qualify as an affected tenant and you know are unable to pay rent because of being an affected tenant, then you should not also be charged late fees with respect to those particular rental payments. After the fact, I guess, you know, then that relief would then be would be lifted. I'm guessing.
Okay, so the way I'm understanding the current, what's on the table now is, and I'm going to have to tweak one other word. Right now it says a landlord may not. I need to change that may to shall. So landlord shall not terminate the tenancy of a tenant who qualifies as an affected tenant for non-payment of rent, or impose, charge, or collect a late fee or equivalent surcharge related to the non-payment of rent, unpaid due to any reason related to this ordinance.
Oh, I see. You're putting it under the first sentence. Let's see here. Allow me not terminate. Let's go with tenant. Yeah, I mean, I think it works there too. Say, or impose, charge, or collect a late fee or equivalent surcharge for any unpaid rent, or for any rent payments, or for any, for any non-payment of rent
I think it's better to say unpaid rent, because for somebody who makes partial payment, because the late fee would be potentially on the unpaid portion. So let's say for any unpaid rent due to any reason related to this ordinance. Or related to, not due to, but related to, or no, wait. Yeah, due to any reason ordinance. Okay.
How about due to any reason specified under section 7A?
Okay. I think that works.
Okay. The rest of the council have any anything to add to that?
No, I'm good.
Right. Let's see here. Then removing the gross receipts, Ellis Act removals. Let me just look at my. Okay, so bear with me. Sorry, I'm kind of trying to scan and collect my thoughts at the same time. Can we go back to the Ellis Act removal provision here, and that still being a basis on which landlords could evict tenants? What I recalled you saying, Norma, was that the Ellis Act would allow a landlord to, under normal circumstances, Ellis Act would allow tenants to remove tenants if they were taking the units off the market completely, or converting them from for lease to for sale units, or perhaps tearing down the current structure and putting something else up. Are those the sort of scenarios in which that we're talking about here?
Yeah, because what it's trying to do, the intent of that law is to prevent landlords from evicting tenants that are under rent control in order to just turn around and then rent it to other individuals at market value, or at fair market rent. And so that's why those additional protections are in place, where if they're doing that, they have to essentially take it off the market completely. So they also can't like pinpoint and say, okay, we're going to get rid of these 2 tenants, but not the other 8. And so that's really what it's structured to do, which is why in a community like San Gabriel, I don't know that that's something that's necessarily used frequently or is a primary concern, as opposed to, let's say, a place like Santa Monica or West Hollywood, where there's very strict rental protections in place. But I may be wrong.
Well, let me. So first of all, would it be legally permissible for us to remove that as a basis for a just cause termination under this ordinance? In other words, to actually then eviscerate the Ellis Act during the period of this moratorium?
Technically, yes, in the sense that the executive order that the state passed on March 16th did give pretty broad authority to local governments to enact substantive limitations such as that. From a practical matter, as I stated earlier, with the long runway of 120 days notice, and there's like periods of response, and it's sort of this very involved process, and the likelihood that anybody would actually evoke the Ellis Act is maybe low. And so from a practical matter, I don't know that it would be like the most important protection that we'd have to worry about barring, which is what we'd have to do affirmatively.
Right, I see.
Because again, it wouldn't be sufficient to just strike it from the just cause section, because by striking it, it doesn't take away the right that landlords have.
But I'm still a little bit confused. Is the sort of the purpose of the Ellis Act to protect those lower rent tenants, or to protect the landlords, or provide a process by which the landlords can otherwise, I guess, still evict the tenant, even if there were other sort of like rent control or other sorts of laws in place? Is that, I guess that's
it's definitely a tenant protection law, but where it matters is where there are rental restrictions already in place, like that in a city that's very tenant friendly, and where landlords want to evict people for just because who are under rental protection, and so that's what this is trying to do, to prevent landlords from just being able to come in and say, oh, we want to take this unit off the market, or these 2 units, and then we're going to turn right back around and rent them at a higher rent. And so that's why, in order to evoke this Ellis Act, a landlord is forced to completely take the entire property off the rental market. I believe there's a 7-year period that has to happen. And so there are sort of these hurdles that landlords have to jump, or rules that they have to abide by in order to avail themselves of this opportunity. But at its core, it's intended to protect tenants that are under in jurisdictions that have tight rent controls.
I see. Would it also apply, for example, to Section 8 tenants?
That I don't know. Let me see. So you're envisioning a building that has some portion of Section 8 tenants, or all Section 8 tenants, and so can a landlord evoke the Ellis Act to take those units off the market? Yeah, I mean, I'd have to look into the weeds about that. And I mean, my recommendation for purposes of tonight, because this would be a pretty significantly substantive change, is if this were something that the council felt very strongly about, that we wanted, a future meeting to have an amendment or an addition that affirmatively removed this eviction right from landlords. That's something that we can look into more closely. But given,
my thinking, I mean, this was intended to provide rights to renters, the Ellis Act. It is a process for evictions, but it's actually really a limitation on the ability to evict. So if you were to remove it, I think it would have potentially a perverse and unintended consequence in this particular case, although it seems likely to ever come up because the lead time on it is 120 days, which ideally will be when we're done with this anyway. So I think this is probably a bit of a rabbit hole tonight.
Okay. Yeah, I think I feel convinced, because I'm not familiar with the Ellis Act. I just wanted to make sure we understood what policy we're implementing here. It sounds to me like it is meant to be a tenant protection. However, in that balancing act, it has a lot of requirements for landlords to be able to avail themselves of an eviction under this Ellis Act. So yeah, I just want to make sure I understood fully, what the implications are. And as you both have mentioned, I think that's probably the practical implication for us is low.
Yeah, and if I can, I can underscore that it's listed there. Again, we can delete it, but it doesn't have any practical effect in terms of removing that right from a landlord. So it's listed there just as an example, like the others, of ways that landlords can still avail themselves of right to evict. So if we were really concerned about wanting to ban it, we'd have to do it affirmatively. The fact that it's listed there doesn't have an impact one way or another in terms of both landlords or tenants. It just is.
Yeah. I'll just note, actually, the reason I sort of paid more attention to it was also because looking at Governor Newsom's order, LA County's order, and Mayor Garcetti's order for the city of LA, only Mayor Garcetti's order for the city of LA actually specifically said that, you know, even evictions under the Ellis Act are not allowed. And so that's why I wondered, well, why is that? And so now understanding, you know, how the act operates a little bit better, I think you're right that it probably doesn't have as much practical implication. And if it, hopefully, you know, we definitely hope that within 180 days or 120 days that, you know, we'll be clear of the stay-at-home type of orders that, you know, we're all under. The last one I just wanted to touch upon is in subsection A8B, criminal activity. So, as I understand this subsection as a whole, evictions would be allowed to, or eviction of a quote-unquote violating tenant would be allowed, and it seems that this subsection contemplates situations where one member of a household might be indicted by a grand jury or you know, held to answer for a serious or violent felony. And I can understand why we would want to basically separate out those who might be serious or violent felons from other members of a household. My question on the latest draft of the ordinance here is, why is there, or can you talk about the limitation at the very end, which says that a violating tenant has to have had one of those things, you know, indicted by a grand jury, held to answer pursuant to Penal Code Section 872 for a serious felony, or a violent felony under Penal Code Section 667.5C, and then also which occurred during the tenancy.
Yeah, the reason that language is there is because landlords are not permitted to use past criminal history of tenants as a factor in determining whether or not, you know, we can, that's not supposed to come up in making decisions about whether or not to rent. And so that's why we're limiting the time frame where somebody, you know, quote unquote, becomes a violating tenant as, you know, beyond that point. And so that's why that language is there. It's intended to cover only like forward from when this person became a tenant, as opposed to treating some past violation.
So notice, though, that the definition is not tied to the actual activity or behavior that would cause them to be indicted by a grand jury or held to answer as a serious or violent felon. So you're saying that if the person is indicted or somehow arrested or something like that for serious felony or violent felony, then that would be grounds to be able to evict that particular person. But it has to be during the tenancy.
Right, because if it happened before, we wouldn't be, as a landlord, we wouldn't be able to avail ourselves of that factor in determining whether or not to rent to the person. And obviously, if it happens after, we're only talking about the present, right? So that sort of starts the clock is when the tenancy began. So that's why that's there.
Okay, I think I understand and agree. Sorry, I just wanted to make sure that then it's I guess it would cover situations though too if somebody were recently violent, recently a violent or serious felon, but then happened to be indicted while they were a tenant. So the activity actually occurred before the tenancy, but they were indicted while they were a tenant. Actually, it would cover those situations as well.
Yes, that is correct. That is the way it's drafted.
Okay, then I'm good with that too. Just thanks for bearing with me on those points. So let's see here. Then going back to the overall ordinance, we have made amendments to section 6A with respect to late fees related to unpaid rent.
Hello?
And hello?
There we go. Oh, yeah.
And I'm trying to find the last one here.
The gross receipts, it's section 7A5. We eliminated Roman numeral 3 that made reference to the 5 million cap.
Right. Okay. So with that, is there a motion from the council with respect to the ordinance as amended?
I'll move.
Motion to approve this amendments.
Okay, I have a motion from Councilmember Liao.
I'll second.
Oh,
Okay, I think that was Vice Mayor Menchaca as a second.
that's fine.
Yes.
Okay. All right, we have to do this by roll call. So, Councilwoman Costanzo.
Yes.
Councilmember Harrington.
Aye.
Councilmember Liao.
Aye.
Vice Mayor Menchaca.
Aye.
And myself, aye as well. So we have a unanimous approval of the ordinance as amended. Let's see. Actually, since I wasn't preparing to preside over here, I guess I was supposed to request a voice vote to be called by the clerk, but hopefully that's still all right. Is that still effective?
That's perfect.
It is.
Okay. So motion passes by a vote of 5 ayes, 0 nays, and 0 abstentions. And with that, I think we are adjourned for the evening. The next regular city council meeting will be held on Tuesday, April 7th, 2020 at 6:30 p.m. And again, I want to thank everybody for participating on this sort of emergency meeting, and also under these extraordinary circumstances, and bearing with us because it's the first time we've conducted a meeting by telephone conference. But thanks again, everybody, and have a good evening.